Good morning, everyone. Today, we will be examining a problem question concerning the criminal liability for rape. Disclaimer: the content of this video is provided for educational and informational purpose only. We encourage you to review the complete disclaimer. Let's start with the problem question. We have to discuss these possible criminal liability for the rape in the following situation. The scenario one, D promises his girlfriend B, a religious person who does not believe in sexual intercourse before the marriage, that he will marry her if she has a sexual intercourse with him. After the intercourse takes place, D tells V that he did not mean what he said and ends the relationship. D, who looks like the film star George Clancy, induces V into having a sexual intercourse with him, falsely representing that he is George Clancy. The third scenario, D, who is happily married to B, comes home to find her asleep and starts having sexual intercourse with her. She wakes up and tells him to stop. The scenario four, in a bar, D secretly buys V an alcoholic cocktail rather than non-alcoholic drink she asks for. V does not notice the difference and becomes intoxicated. D drives V back to her flat, where, after a long session of petting, they have a sexual intercourse. And the final scenario, D and V, who are the lovers, are having a consensual intercourse during which D says to V, I wish you were more passionate. You are not nearly as sexy as Marta, who is D's ex-wife. V angrily tells D to cease the intercourse. D refuses, whereupon V shouts, Get off, and begins to struggle. That's better, says D. Now you are showing a bit of patience and continues to have intercourse with her. Let's analyze each and every scenario in detail. Before analyzing the D's criminal liability for the rape, rape is defined under the Section 1 of the Sexual Offences Act 2003 as the intentional penetration of the vagina, anus, or the mouth of another person with a penis without that person's consent, and where the defendant does not reasonably believe the victim's concerns. Concern is further clarified under Section 74, while the Section 75 and 76 introduce evidential and conclusive presumption about the concern. In this scenario, the D promises his girlfriend V that he will marry her if she has intercourse with him, but later admits he lied. So here, the D's action may amount to rape if V's concern was vitiated by deception. The concern under the Section 74 require the agreement by the choice, with the freedom and the capacity to make that choice. While V appear to concern, the decision was based on D's false promise of marriage. However, Section 76 2A provides that deception as to the nature or the purpose of the acts conclusively negates the consent. In the case R versus Zeta in 2007 case, the court held that the lies about the external matters, such as the false promise, do not vitiate consent under Section 76, but must be asserted under the Section 74. Here, in our case, these false promise does not relate to the nature or the purpose of the sexual act, but rather to the external circumstances. While morally reprehensible, it is unlikely to vitiate the V's concerned under the Section 74 unless it can be shown that she lacked the freedom to choose due to the deception. Hence, D is unlikely to liable for the rape in this scenario. In other words, the Section 74 of Sexual Offences Act 2003 defines the concerned as if he agrees by choice and has the freedom and the capacity to make that choice. We, a deeply religious person, may argue that the promise of marriage significantly influenced her decision to have the sex with thee. If she felt that the promise was genuine and was motivated by the religious belief, she may claim that her consent was not given freely but was vitiated by these false promises. In the R versus Williams case in 1923, discussed the concept of vitiated consent due to deception, where the deception involved a significant misrepresentation, though in R versus Lawrence case in 2020, the court emphasized that deceptions unrelated to the physical acts itself. In this case, a lie about for example, a lie about the vasectomy did not vitiate the concerns. So, in our case, the deception about the marriage may influence the moral and emotional aspect of the concerns, but simple deception, such as the promise, that does not affect the physical act of the intercourse, is insufficient to vitiate the consent under the section 76 unless it involves a fundamental deception about the nature of the act itself. Thus, while we may have been deceived, it is unlikely that this deception alone would lead to a conviction of for a rape unless the jury determines that the promise was critical to her consent. The mens rea for the rape under the section 11C requires that D must have known or been reckless about the fact that V was not concerning. Since D knew V would not have concern had she knew the truth, he may lack a reasonable belief that V consented, which would affect the issue of a mens rea. In this scenario, like scenario two, D pretends to be the film star George Clancy to induce V into the intercourse. That D's impersonation it raises the issue under the section 76(2)(b, which establishes a conclusive presumption of no consent, where the defendant intentionally deceives the victim as to their identity. In R versus Elbeke case in 1995, the court held that impersonation of a person known personally to the victim negates the consent. However, in R versus D case in 2007, clarified that impersonation must involve someone, the victim, known personally for the section 76 to apply. Here, these deceptions about being a George Clancy relate to his identity, but does not involve the impersonating someone known to me personally. As such, Section 76 does not apply. Instead, a V's consent must be assessed under Section 74. While these deceptions may render the V's consent invalid if it can be shown that her agreement was entirely based on false representation. The absence of the Section 76, the conclusive presumptions, makes D's liability less clear. In other words, in this case, the D impersonate a person known to be, in this case, a film star. Under the section 76(2)(b of SOA 2003, there is a conclusive presumption of no consent if the defendant impersonates someone personally known to the victim and the victim has intercourse with the defendant as a result of impersonation. In R versus Elbeke case in 1995, established that impersonating a person known to the victim, such as a partner or the close friend, it's vitiate consent. However, in R versus Gita case in 2007, emphasize the strictness of this presumption, where the person must be known personally to the victim. In our scenario, the George Clancy is unlikely to be considered a person personally known to me as a film star, would not typically have a personal relationship with a fan. Therefore, the conclusive presumption of no concern under Section 76(2)(b) would not apply. Instead, the case will likely rely on Section 74 as the general definition of the consent. We may argue that had she knows the truth, she would not have intercourse with D. The key issue is whether we consent in the first place. If the court determines that we did not consent, then the mens rea for the rape must be established. If D reasonably believed the V is consent, he may avoid conviction, but this would be for the jury to determine based on the evidence presented. Let's move on to the scenario. Third scenario, a D married to B has an intercourse with her while she is asleep, and she tells him to stop after waking up. Under Section 75(2)(d), there is a rebuttable presumption of no concern if the victim is asleep or unconscious during the act. In R versus Latter and Castleton case in 1995, the court confirmed that a sleeping person cannot consent. These actions clearly fall within this provision for the period when B was asleep. When B wakes up and explicitly tells D to stop, any consent that might have existed previously is unequivocally withdrawn. The intercourse thereafter is non-consensual. Under Katamaki case versus All in 1985, the sexual intercourse is a continuing act, and lack of consent at any point renders the act a rape. Thus, D is liable for the rape both while V was asleep and after she demanded he to stop. In other words, this in scenario invokes Section 75(2)(d) of SOA 2003, which provides a rebuttable presumption that if the victim is asleep or unconscious at the time of intercourse, they cannot consent. The actus of the rape is satisfied as D engage in sexual intercourse without V's consent while she is asleep. The presumption of no concern under Section 75(2)(d) applies here, but it can be rebutted if D can demonstrate that B did, in fact, a consent. However, once V wakes up and tells D to stop, it is clear that V has withdrawn her consent, and D's continued action after V's refusal to stop indicate a lack of consent. The mens rea for the rape under the section 11C requires D to have a reasonable belief in V's consent, given that V clearly withdrawn the consent once she woke up. D could not reasonably believe V was consenting. As such, D is likely to be found guilty of rape. Let's break down the scenario 4. D secretly buys V an alcoholic cocktail. It's causing intoxication and they later have intercourse. These secret provisions of alcohol raises the question under Section 75(2)(f), which presumes a lack of consent. If the victim was substantially impaired by intoxication caused by the defendant's action. In R versus Bree case in 2007, the court held that intoxication alone does not negate the consent unless it deprives the victim of the capacity to choose. Here, the V's intoxication is a result of these decisions. But the key issue is whether she retained the capacity to consent. If V's intoxication rendered her incapable of making a free and informed choice, her concerns would be invalid under the Section 74. However, if she retained the capacity and agreed to intercourse, D may avoid the liability unless the prosecution can prove that her intoxication substantially impaired her decisions making ability. In other words, the scenario invokes Section 75(2)(f) of Sexual Offences Act 2003, which applies if the defendant causes the victim to become intoxicated by substance, alcohol in this case, without the victim's consent, leading to the presumption that victim is unable to consent. In R versus Bree case, 2007, addressed the issue of intoxication and the concern, confirming that a victim who is intoxicated may still concern if they have the capacity to do so. However, in our case, the key issue is whether we have the capacity to consent after becoming intoxicated. The fact that we was intoxicated means there is a presumption of no concern. These action in administering the wrong drink can be seen as an omission or a deceptive act that led to we being intoxicated, as in R versus DPP case versus Morgan in 2002. The court would likely examine whether D believed V's consent to the intercourse. Given that we became intoxicated due to D's action, it is unlikely that D had a reasonable belief in her consent. Therefore, the presumption of no consent under the section 75(2)(f) is likely to apply here. Let's examine the final scenario. During the consensual intercourse, we withdraw the consent, but D continues despite her protest. A concern can be withdrawn at any time during the sexual intercourse, as established in Katamaki case versus R in 1985, when V angrily told D to stop and began to struggle. Any previous concern was unequivocally withdrawn. These continued intercourse thereafter constitute the rape. These remarks, such as, that's better, now you are showing a bit of passion, suggest an awareness that we was no longer concerning. Under Section 1D, cannot argue a reasonable belief in concern, as his actions demonstrate a clear disregard for V's withdrawal of concern. This scenario constitutes a rape under the Section 1 and 74. In other words, in this case, a V's verbal withdrawal of concern and struggling demonstrates a clear revocation of concern, as recognized in R versus Olugja case in 1982. Once V says get off and struggles, she has a clearly communicated her refusal. Section 74 requires that concern is given by choice and with freedom. These continued actions in the face of V's clear objection indicate that he did not respect her withdrawal of consent. In R versus Asangi case in 2012, similarly addressed the issue of concern and withdrawal during the sexual intercourse, reinforcing that once concern is withdrawn, further intercourse without the concern constitute rape. Therefore, these actions are likely to lead to a conviction for the rape, as he did not respect V's refusal. Let's conclude. These potential criminal liability for the rape varies in each situation. In scenario A and B, the section may not vitiate the concern unless it involves a fundamental lie about the nature of the act, as in McNally case. While in the scenario C, the third one, the presumption of non-consent due to V's being asleep makes it clear that V is liable for the rape. In the scenario 4, D's action in secretly intoxicating V lead to a presumption of no consent. And in the final scenario, D's failure to stop the intercourse after we withdraw the consent means he could be convicted of rape. The mens rea for the rape is central to these cases as it hinges on D's knowledge and belief regarding the V's consent. Thank you.